everyone, my name is Matthew M. Villarreal. Now, we will going to discuss the continuation of the topic. This is still under the Republic Act number 11232, an act providing for the revised Corporation Code of the Philippines, title number 6. Alright, so this title, or title number 6, is actually meetings, right? Now, so before we will going to talk about the different sections under this title. Let me go ahead and give you first the scope. What would be the information that we will going to talk about when we say meetings? Alright? So generally, stockholders meetings are called for the purpose of electing directors or trustees and transacting some other business, calling for requiring action of consent of the shareholders or members, such as the amendment of the Articles of Incorporation and bylaws, sale or disposition of substantially all corporate assets, consolidation and merger the like, or any other business that may properly come before the meeting. Now let's talk about the different sections under this title. Section number 48, kinds of meeting. Meetings of directors, trustees, stockholders, or members may be regular or special. And in section 49, we will be able to know the difference between the regular and special meeting of stockholders and members. So let's start with the regular meeting. Stockholders or members shall be held annually on date fixed by the laws, or if not so fixed, on any date after April 15 of every year, as determined by the Board of Directors or Trustees, provided that written notice of regular shall be sent to all stockholders or members of record at least 21 days prior to the meeting, unless a different period is required in the bylaws, law, or regulation. Provided further, the written notice of regular meetings may be sent to all stockholders or members of record through electronic mail or email, or such other manner as the Commission shall allow under its guidelines. Alright? So now, each meeting of stockholders or members, the Board of Directors shall endeavor to present to stockholders or members the following. First, the minutes of the most recent regular meeting, which shall include a description of the voting and vote tabulation procedures used in the previous meeting, a description of the opportunity given to stockholders or members to ask questions, and a record of the question asked and answers given, the matters discussed and resolutions reached, a record of the voting results for each agenda item, a list of the directors, officers, and other stockholders who attended the meeting. Such other item that the Commission may require in the interest of good corporate governance and the protection of minority stockholders. So yun daw po dapat yung nilalaman ng ating minutes of the meeting. Second, a members lists for non-stock corporation and for stock corporation, material information on the current stockholders and their voting rights. Third, a detailed, descriptive, balanced, and comprehensible assessment of the corporation's performance, which will include information on any material change in the corporation's business, strategy, and other affairs. Fourth, a financial report for the preceding year, which shall include financial statements duly signed and certified in the accordance with this code and the rules of the Commission, may prescribe a statement on the adequacy of the corporation's internal controls or risk management system, and a statement of all external audit and non-audit fees. 6. Directors' profiles, which shall include their qualifications and relevant experience, length of service in the corporations, trainings, and continuing education attended in their board representations and other corporations. 7. A director attendance report indicating the attendance of each director or trustee at each of the meetings of the board and its committees and in regular or special stockholders meetings. 8. Appraisals and performance reports for the board and the criteria procedure for the assessments. 9th, a director's compensation report prepared in accordance with this code and the rules for the commission may also actually prescribe. Next, director's disclosure on self-dealings and the related party transactions. Last, the profiles of the directors nominated or seeking election or re-election. Now, a director, trustee, stockholder, or member may propose any other matter for inclusion in the agenda at any regular meeting of stockholders or members. Now let's talk about special meetings. Special meetings of stockholder or members shall be held at any time deemed necessary or as provided in the bylaws. Provide, however, that at least 1 week written notice shall be sent to all stockholders unless a different period is provided in the bylaws, law, or regulation. A stockholder may propose the holding of a special meeting and items to be included in the agenda. The difference between the regular meeting and special meeting is regular meeting must be posted minimum of 3 days or 72 hours before the meeting begins, and also to give the public time to see the notice and plan to attend. While special meetings are held to deal with specific business so urgent it and cannot wait until the next regularly scheduled meeting. In case of postponement of stockholders' regular meetings, written notice thereof and the reason therefore shall be sent to all the stockholders of record at least 2 weeks prior to the date of the meeting unless a different period is required under the bylaws, law, and the regulation. Next, Section 50, place and time of meetings of stockholders. Stockholders or members meeting, whether if it is a regular or special, shall be held in the principal office of the corporation as set forth in the articles of incorporation, or if not applicable in the city or municipality where the principal office of the corporation is located, provided that any city or municipality in Metro Manila, Metro Cebu, Metro Davao, and other metropolitan areas shall, for purposes of this section, considered a city or municipality. Notice of meeting shall be sent through the means of the communication provided in the bylaws, which notice shall state the time, place, and other purpose of the meeting. Each notice of the meeting shall further be accompanied by the following. First, the agenda of the meeting. Second, a proxy form, which shall be submitted to the corporate secretary within a reasonable time prior to the meeting. Third, when attendance, participation, and voting are allowed by remote communication or in absentia, the requirements and the procedure to be followed when the stockholders elects either options. Fourth, when the meeting is for the election of the directors and trustees, the requirements and procedure for the nomination and election. All procedures and operation performed when a stockholder or member is within the authority of the company are valid, even if the meeting is improperly held or called. However, stockholders who have explicitly declared that the purpose of their participation is inconsistent with commerce because all stockholders of the company are present or formally represented and the meeting has not been legally convened. Other reporter for the next sections, thank you very much for listening.
Hi everyone, this is Maisel Di Balaguer and I will be the one who will discuss Section 51 to Section 53 of Revised Corporation Code, Title 6, Meetings. So now let's discuss Section 51, quorum in meetings. So unless otherwise provided in this code or in the bylaws, a quorum shall consist of the stockholders representing a majority of the outstanding capital stock or a majority of the members in the case of non-stock corporations. So when we say outstanding capital stock, it is the total shares of stock issued to subscribers or stockholders, whether or not fully or partially paid except treasury shares, so as long as there is a binding subscription agreement. So for stock corporations, the quorum referred to in Section 52 of the Corporation Code na ngayon is Section 51 na ng Revised Corporation Code is based on the number of outstanding voting stocks. And para naman sa non-stock corporation, yung mga actual or yung mga buhay pa na members with voting rights, sila lang yung mga counted and yung mga dead members shall not be counted. So under Section 51 of Revised Corporation Code, the majority of the members representing the actual number of voting rights, not the number or numerical constant that may originally be specified in the Articles of Incorporation, constitutes the quorum. So ano nga ba ang quorum? So quorum, in simple terms, it is the minimum number of attendees required to be present before an official meeting can take place. What should be the basis of quorum for a stockholders meeting? The outstanding capital stock as indicated in the Articles of Incorporation or that contained in the company stock and transfer book? So to base the computation of quorum solely on the obviously deficient if not inaccurate stock and transfer book and completely disregarding the issued and outstanding shares as indicated in the Articles of Incorporation would work injustice to the owners and or successors in interest of the said shares. Resort to documents other than the stock and transfer book is necessary. Yung stock and transfer book, hindi siya pwedeng gamitin as the sole basis for determining the quorum as it does not reflect the totality of shares which have been subscribed. More so when the Articles of Incorporation show a significantly larger amount of shares issued and outstanding as compared to that listed in the stock and transfer book. So ngayon, ano nga ba yung sinasabi nating Articles of Incorporation and Stock and Transfer Book? So yung the Articles of Incorporation has been described as one that defines the charter of the corporation and the contractual relationships between the state and the corporation, the stockholders and the state, and between the corporation and its stockholders. So Articles of Incorporation, sometimes called a certificate of formation or a charter, and set of documents filed with a government body to legally document the creation of a corporation. So yung ganitong klase ng legal document contains general information about the corporation, kasama na dito yung mga businesses names and locations. And yung stock and transfer book naman is book siya na nire-record lahat ng names and addresses of all stock holders arranged alphabetically. Yung mga installments na bayad na, yung mga hindi pa bayad, and yung mga date of payment thereof. So a stock and transfer book is necessary as a measure of precaution, expediency, and convenience since it provides the only certain and accurate method of establishing the various corporate acts and transactions and of showing the ownership of a stock and like matters. So in other words, pag sinabi natin na stock and transfer book, it is the registry of ownership in a corporation. It is the official record of equity ownership, of stockholder status, and or those who are entitled in vote in meetings. Now, let's discuss meetings of stockholders or members. So, dito, i-discuss natin kung ano at kung paano makakapag-participate yung mga stockholders and yung mga members sa meetings kahit hindi sila makaka-attend physically. So, when so provided in the bylaws or by majority of the board of directors, yung mga stockholders or members na hindi makaka-attend physically at stockholders or members meetings, pwede sila mag-participate in such meetings through remote communications, like video conferencing, teleconferencing, or other alternative modes of communication. So, if a stockholder or member intends to participate in a meeting through remote communication, dapat niyang sabihan or i-notify in advance yung presiding officer and the corporate secretary of his or her intention. So, the corporate secretary shall note such fact in the minutes of the meetings. So, yung mga stockholders or yung mga members na magpa-participate through remote communication or in absentia, they shall be deemed present for purposes of quorum. Voting in the election of directors, trustees, and officers through remote communication. So, dito pinag-uusapan dito yung karapatan or yung rights ng mga stockholders and ng mga members na bumoto through remote communication. So, the right to vote of stockholders or members may be exercised in person through a proxy or when so authorized in the bylaws through remote communication or in absentia. The right to vote of stockholders or members may be exercised also through remote communication or in absentia when authorized by a resolution of the majority of the board of directors, provided that the resolution shall only be applicable for a particular meeting. So, sa election of directors, trustees, and officers of corporations vested with public interest, yung mga stockholders and members may vote through remote communication or in absentia, notwithstanding the absence of a provision in the bylaws of such corporations. So, para sa convenience ng mga stockholders and yung mga members, yung corporation kailangan nilang mag-issue ng internal procedures embodying the mechanisms for participation in meetings and voting through remote communication or in absentia. The internal procedures may take into account the corporation's number of stockholders, the location of stockholders or members, importance of the matters to be discussed and voted upon in the meeting, promotion of minority rights, and other factors consistent with the protection and promotion of stockholders or members' rights. The internal procedures may provide for the following. First, a mechanism to verify the identity of the stockholders or members and kung sino sa kanila yung may karapatang bumoto during the meeting. Second, measures to ensure that all stockholders or members have the opportunity na makapag-participate sa meeting, including an opportunity na magbasa and also makinig sa discussion substantially. Third, a mechanism to enable stockholders or members to vote during the meeting, including ensuring that the integrity and secrecy of the votes are protected. Fourth, procedures for documenting the meeting in any process motion which may be done afterwards. Fifth, mechanism in making the record of the meeting. Pwede siyang video or audio recording available to the stockholders or members. And last is other matters to address administrative, technical, and logistical issues. Now, pag-usapan natin yung mga notices of the meetings. So, the secretary shall send out the notices of the election or the meeting to all stockholders or members in accordance with the manner of giving notice as stated in the bylaws. Yung written notice of regular meetings may be sent to all stockholders or members through electronic mail or such other similar manner as may be stated in the bylaws. Notice of regular meetings which state the date, yung time, and yung place ng meeting must be sent to every stockholders or members at least 21 days prior to the scheduled meeting unless a longer time is provided in the bylaws. Kagaya naman dun sa regular meetings, yung para naman sa special meetings, kailangan nakastate yung date, yung time, and yung place ng meeting must be sent to every stockholders or members at least 1 week naman to prior to the scheduled meeting unless a longer time is provided in the bylaws. So, in the case of postponement of stockholders or members' regular meetings, written notice shall be sent to all stockholders or meetings of record at least 2 weeks prior to the date of the meeting. The notice shall further be accompanied by other relevant matters such as the following. First is the agenda of the meeting. Agenda. It is very important because it is used to organize meetings, gives a time frame for what items are to be discussed, and provides a clear understanding of a common end goal for the participants. And also, they provide guidance and preparation for the following meeting. So, yung pangalawa is when attendance, participation, and voting by remote communication or in absentia are authorized, yung mga requirements and yung mga procedures is to be followed when a stockholder or member elects either option. Pangatlo, manner of casting of votes and the period during which vote by remote communication or in absentia will be accepted. Pang-apat, contact information of the secretary or office staff whom the stockholder or member may notify about his or her option. Panglima, when the meetings is for the election of directors or trustees, yung mga requirements and yung mga procedures for nomination and election. And last is the fact that there will be visual and audio recording of the meetings. This is for future reference. So now, let's talk about place of meetings of stockholders or members. So yung presiding officer, sila yung gagawa or magtatawag ng meetings, whether regular or special meeting yan, at the principal office of the corporation as provided in the Articles of Incorporation. Kapag hindi naman siya feasible or practicable, pwede naman sa city or municipality where the principal office of the corporation is located. So now, we are already in section 52, regular and special meetings of directors or trustees, quorum. So unless the Articles of Incorporation or the bylaws provides for a greater majority, a majority of the directors or trustees as stated in the Articles of Incorporation shall constitute a quorum to transact corporate business, and every decision reached by at least a majority of the directors or trustees constituting a quorum, except for the election of officers, which shall require the vote of a majority of all the members of the board, shall be valid as a corporate act. So, regular meetings of the board of directors or trustees of every corporation, pwede silang ganapin monthly unless the bylaws provide otherwise. And para naman sa special meetings, pwede siyang ganapin anytime upon the call of the president or as provided in the bylaws. Meetings of directors or trustees of corporations may be held anywhere. Pwede siyang in or outside of the Philippines unless the bylaws provide otherwise. So, notice of regular or special meetings stating the date, yung time, and yung place ng meeting must be sent to every director or trustee at least 2 days prior to the scheduled meeting, unless a longer time is provided in the bylaws. So, yung director or trustee may waive this requirement either expressly or impliedly. And para dun sa mga directors or trustees na hindi makaka-attend physically or makakapag-vote physically at board meetings, pwede silang mag-participate and mag-vote through remote communication. Ito din yung such as video conferencing, teleconferencing, or other alternative modes of communication that allow them reasonable opportunities to participate. Yung mga directors or trustees cannot attend or vote by proxy at board meetings. A director or trustee who has a potential interest in any related party transaction must recuse from voting on the approval of the related party transaction without prejudice to compliance with the requirements of Section 31 of this code. The general rule here is that the corporation, through its board of directors, should act in the manner and within the formalities, if any, prescribed by its charter or by the general law. Thus, directors must act as a body in a meeting called pursuant to the law or the corporation's bylaws. Otherwise, any action taken therein may be questioned by any objecting director or shareholder. So now, let's discuss quorum at a regular or special meeting of directors or trustees. So the general rule here is that majority of the number of directors or trustees as stated in the Articles of Incorporation. And the exemption is if the Articles of Incorporation or the bylaws provide for a greater majority. So for valid corporate act, the general rule is every decision reached by at least a majority of the directors or trustees constituting a quorum shall be valid as a corporate act. But the exemption is the election of officers shall require the vote of a majority of all the members of the board. So what is the quorum at the meeting of directors or trustees? So a majority of the directors or trustees as fixed in the articles of incorporation shall constitute a quorum for the transaction of corporate business, and every decision of at least a majority of the directors or trustees present at the meeting at which there is a quorum shall be valid as corporate act, except for the election of officers which shall require the vote of a majority of all the members of the board. So kapag sinabi nating majority, it means 50% plus 1. So now, let's move on to section 53, who shall preside at meetings, who shall be in the position of authority in a meeting. So the general rule here is that the chairman, or in his absence, the president shall preside at all meetings of the directors or trustees as well as of the stockholders or members. The exemption is unless the bylaws provide otherwise. So para sa board meetings of directors or trustees is kagaya lang siya ng board meetings of stockholders or members na kapag hindi naka-attend physically or makapag-vote physically yung mga directors or trustees, pwede sila makipag-participate and pwede sila mag-vote through remote communication. Yun nga, such as video conferencing, teleconferencing, or other alternative modes of communication. And also, directors or trustees cannot attend or vote by a proxy at board meetings. And also, if a director or trustees intends to participate in a meeting through remote communication, kailangan nilang i-notify or sabihan in advance the presiding officer and the corporate secretary of his or her intention. The corporate secretary shall note such fact in the minutes of the meeting. Corporations may issue their own internal procedures for the conduct of board meetings through remote communication or other alternative modes of communication to address administrative, technical, and logistical issues. A majority of the directors or trustees as stated in the Articles of Incorporation shall constitute a quorum, and yung director or yung trustee na magpa-participate through remote communication shall be deemed present for the purpose of attaining quorum. Yung notice of the meeting dito para sa directors or trustees is kagaya lang din dun sa notice ng para sa stockholders or members. So, roll call. So, when we say roll call, it is the process of calling out a list of names to establish who is present. So, at the start of the meeting, the presiding officer shall instruct the corporate secretary to make a roll call. So, every attendee shall state for the record the following. Of course, first is their full name and position. Their location, confirmation that he or she can clearly hear and see the other attendees, confirmation that he or she received the notice of the meeting, including the agenda and the materials, and last is to specify the device being used, for example, television, smartphone, desktop, tablet, laptop, and etc. So kapag pag-uusapan ng voting, in case of a need to vote in any item or matter in the agenda, the presiding officer shall direct the corporate secretary to note the vote of each director or trustee. And para dun sa mga director or trustee na nagpa-participate sa meeting via remote communication, may cast his or her vote through electronic mail, messaging service, or such other manner as may be provided in the internal procedures. The vote shall be sent to the presiding officer and the corporate secretary for notation. So now, pag-usapan natin yung other duties and responsibilities of the corporate secretary. So first, they need to ensure that the suitable equipment and facilities are available for the conduct of meeting by remote communication. They need to ensure that the attendees are able to hear and see the other participants clearly during the course of the meeting, and that attendees should be able to communicate and understood by the other party. Yung mga visual and yung mga audio recordings ay kailangan nakasecured and kailangan tuloy-tuloy yung pagre-record and walang interruption na magaganap. Once na nagkaroon ng interruption, yung pag-record, kailangan niyang mag-restart from the point where it was stopped or recording or interrupted with proper statement of points in time, of course. And yung mga audio and yung mga visual recordings na yun is kailangan makip siya sa updated date storage equipment or facility. And last is kailangan i-require lahat ng mga umattend doon sa meeting through remote communication to sign the minutes of the meeting whenever the act of signing is practicable on a reasonable time after the meeting.
Section 54, right to vote of secured creditors and administrators. So, in case a stockholder grants a security interest in his or her shares in stock corporations, the stockholder shall have the right to attend and to vote at meetings of stockholders, unless the secured creditor is expressly given by the stockholder grantor the right in writing, which is recorded in the appropriate corporate books. So, executors, administrators, receivers, and other legal representatives duly appointed by the court may attend and vote on behalf of the stockholders or members without the need of any written proxy. Section 55, voting in case of joint ownership of stock. So, in case of shares of stock owned jointly by two or more persons, in order to vote the same, the consent of all the co-owners shall be necessary, unless there is a written proxy signed by all the co-owners that one or some of them or any other person to vote such share or shares, provided that when the shares are owned in and or capacity thereof, any one of the joint owners can vote said shares or appoint a proxy therefore. Section 56, voting right for treasury shares. So treasury shares shall have no voting right as long as such shares remain in the treasury. Section 57, manner of voting proxies. So stockholders and members may vote in person or by proxy in all meetings of stockholders or members. So a stockholder or members who participates in remote communication or in absentia shall be deemed for purposes of quorum. So proxies shall be in writing, signed and filed by the stockholders or members in any form authorized in the bylaws and received by the corporate secretary within a reasonable time before the scheduled meeting. So, unless otherwise provided in the proxy form, it shall be valid only for the meeting for which it is intended. Voting trust agreement versus proxy. In voting trust agreement, it is governed by the law on trust, while in proxy, it is governed by the law on agency. So, trustee acquires legal title to the shares of transferring stockholders. Only beneficial title remains with the stockholder. While a proxy, it has no legal title to the shares of principal. So the trustee votes as owner, while a proxy votes as agent. So the agreement must be notarized, while a proxy need not to be notarized. So the trustee may vote in person or by a proxy, while a proxy must vote in person. So the trustee is not limited to act at any particular meeting, while a proxy can only act at a specified stockholders meeting. A trustee can vote even when the stockholder is present, while a proxy, it can only vote in the absence of the owners of the stock. An agreement must not exceed 5 years at any one time, except when the same is made a condition of a loan. While in proxy, it is usually a shorter duration, although the corporation law provides that it cannot exceed 5 years at any one time. As a rule, a voting trust agreement is intended to be irrevocable for a definite and limited period of time, while a proxy, it is revocable. A trustee has the right to inspect corporate books, while a proxy, it doesn't have a right of inspection of corporation books. The stock certificate shall be cancelled and a new one in the name of trustee shall be issued, stating that they're issued pursuant to the voting trust agreement. While in proxy, there is no cancellation of the stock certificate. Requirements for validity of a proxy. So number 1, it shall be in writing in any form authorized in bylaws. Number 2, it shall be signed by stockholder or member. Number 3, it shall be filed before the scheduled meeting with the corporate secretary. Number 4, unless otherwise provided in the proxy form, it shall be valid only for the meeting for which it is intended. And number 5, no proxy shall be valid and effective for a period longer than 5 years at any one time. So take note that directors or trustees cannot attend or vote by proxy, but there is no provision for them to act as proxies at stockholders' meetings. Purposes of proxies. Number 1, for convenience. Number 2, it assures the presence of a quorum. Number 3, it enables those who do not wish to attend the meeting to protect their interest. Number 4, it secures the voting control. So, take note that in the previous section that I discussed earlier, there is no limitation as to who may be a proxy. The right to vote by proxy may be exercised in the following instances. Number 1, election of board of directors or board of trustees. Number 2, voting in case of joint ownership of stock. Number 3, voting by trustee under voting trust agreement. Number 4, voting by members in non-stock corporation. Number 5, in case of pledge or mortgage of shares. Number 6, in all meetings of stockholder or member. And lastly, number 7, in all other matters as may be provided in the bylaws. Revocation of proxies. So, revocation may be made through first, formal notice, second, verbal communication, and third, conduct. So, for example, when the stockholder votes or attends the meeting personally, notwithstanding his appointment of a proxy, in such case, the proxy is deemed revoked. So, take note also that the last proxy given revokes all previous proxies. Section 58, Voting Trust. One or more stockholders of a stock corporation may create a voting trust for the purpose of conferring upon a trustee or trustees the right to vote and other rights pertaining to the shares for a period not exceeding 5 years at any time. So, and these are also the requirements and limitations imposed on voting trust agreement. So, first, that in the case of a voting trust specifically required as a condition in a loan agreement, said voting trust may be for a period exceeding 5 years but shall automatically expire upon full payment of the loan. Then second, a voting trust agreement must be in writing and notarized, and shall specify the terms and conditions thereof. Third, a certified copy of such agreement shall be filed with corporation and with the Securities and Exchange Commission. Otherwise, said agreement is ineffective and unenforceable. So fourth, the certificate or certificates of stock covered by the voting trust agreement shall be cancelled and new ones shall be issued in the name of the trustees or trustees stating that they are issued pursuant to said agreement. So fifth, in the books of the corporation, it shall be noted that the transfer in the name of the trustee or trustees is made pursuant to said voting trust agreement. Sixth, the trustee or trustee shall execute and deliver to the transfer voting trust certificates which shall be transferable in the same manner and with the same effect as certificates of stock. So number 7, no voting trust agreement shall be entered into for the purpose of circumventing the law against monopolies and illegal combination in the strength of trade or used for purposes of fraud. The nature of voting trust agreement. So, by its very nature, the voting trust agreement results in the separation of the voting rights of a stockholder from his other rights, such as the right to receive dividends, the right to inspect the books of the corporation, the right to sell certain interests in the assets of the corporation, and other rights to which a stockholder may be entitled until the liquidation of a corporation. So the three tests of voting trust agreement. However, in order to distinguish a voting trust agreement from proxies and other voting pools and agreements, it must pass 3 criteria or tests, namely, first, that the voting rights of the stock are separated from other attributes of ownership. Second, that the voting rights granted are intended to be irrevocable for a definite period of a time. And third, that the principal purpose of the grant of voting rights is to acquire voting control of the corporation.
My name is Carmely Hamasco and I will be the first reporter introducing the Title VII Stock and Stockholders. Shareholders, both and preferred, are considered stakers na namumuhunan ng puhunan sa negosyo at maaaring tumingin lamang sa kung ano ang natitira pagkatapos naganap na babayaran ang corporate debts and liabilities ng isang kumpanya. In stock corporations, shareholders may generally transfer their shares. Thus, in the death of a shareholder, the executor or administrator duly appointed by the court is vested with a legal title to the stock and entitled to vote it until the settlement and division of the state is affected. The stocks of the decedent are held by the administrator or the executor. Derivative suit is an action brought by a minority shareholder in the name of the corporation to redress wrongs committed against it, for which the directors refuse to sue. It is a remedy designed by equity and has been the principal defense of the minority shareholders against abuses by the majority. It has been proven to be an effective remedy of the minority against the abuses of management. Thus, an individual stockholder is permitted to institute a derivative suit on behalf of the corporation wherein he holds stock in order to protect or vindicate corporate rights. The first one is the party bringing should be a shareholder as of the time of the act or transaction complained of the number of his shares, not be immaterial. Second one is has right to exhaust intra-corporate remedies, has made a demand on the boards of directors for the appropriate relief, but the latter has failed or refused to be heed his plea. The third one is the cause of action actually devolves on the corporation. The wrongdoing or harm having been or being caused to the corporation and not to the particular stockholder bringing the suit. Requirements of derivative suit. Among the basic requirements for a derivative suit to prosper is that the minority shareholder who is suing for and on behalf of the corporation must allege in his complaint before the proper forum that he is suing on a derivative cause of action on behalf of the corporation and all other shareholders similarly situated who wish to join. This is necessary to vest jurisdiction upon the tribunal in line with the rule that is the allegations in the complaint that vest jurisdiction of the court or quasi-judicial body concerned over the subject matter. Suits by stockholders or members of a corporation based on wrongful or fraudulent acts of directors or other persons may be classified into individual suits, class suits, and derivative suits. Derivative suit, where the acts complained of constitute a wrong to the corporation itself. The cause of action belongs to the corporation and not to the individual stockholder or member. Although in most every case, to the corporation, each stockholder is necessarily affected because the value of his interest therein would be impaired. This fact of self is not sufficient to give him an individual cause of action, since the corporation is a person distinct and separate from him and can and should itself to the wrongdoer. Individual suit, where the holder or member is denied the right of inspection, his suit would be individual because the wrong is done to him personally and not to the other stockholders or the corporation. In class or representative suit, where the wrong is done to a group of stockholders as where preferred stockholders' rights are violated. A class or representative suit will be proper to the protection of all stockholders belonging to the same group. Reasons for disallowing a direct individual suit. The reason given is that the judgment must be made binding upon the corporation in order that the corporation may get the benefit of the suit and may not bring a subsequent suit against the same dependents for the same cause of action. In other words, the corporation must be joined as party because it is the cause of action that is being litigated and because judgment must be a res judicata against it. Res judicata means a case that has already been decided or a matter settled by a decision or judgment. subscription contract necessarily involves the corporation as one of the contracting parties, since the subject matter of the transaction is property owned by the corporation's shares of stock. The nature of a subscription contract is it is consensual contract and an indivisible contract. Section 60. Kinds of subscription. Pre-incorporation subscription. It is a subscription for shares of stock of a corporation and still to be formed. These are the rules. A pre-incorporation subscription is irrevocable for a period of at least 6 months from the date of the subscription. These are the exceptions. The first one is all of the other subscribers consent to the revocation. And the other is the corporation fails to incorporate within the same period or within a longer period stipulated in the contract of subscription. No pre-incorporation subscription may be revoked after the submission of the articles of incorporation to the Securities Exchange Commission. And that's the other rule. And the second subscription type is post-incorporation subscription. A subscription entered into after incorporation for the acquisition of an issued stock. The subscriber becomes a stockholder, and upon perfection of the subscription contract, even though he has not paid for his shares, as long as the shares are not considered delinquent, stockholders are entitled to all rights granted to it, whether or not subscribed capital stocks are fully paid. Amount of consideration stock shall not be issued for a consideration less than the par or issued price thereof. Take note that the above provision does not prohibit a corporation from issuing stocks, whereas consideration above the par or issued price. These are the consideration consists of property. These are the requisites. The first one, it must be subject to a fair valuation equal to the par or value of the stock issued. The third one is, if it consists of intangible property, the valuation thereof shall initially be determined by the incorporators or the board of directors, subject to the approval by the Securities Exchange Commission. Note that receivables cannot be treated as cash actually received, since actual payment has yet to take place in the future. They may, however, be considered as property payment subject to the verification by the Securities Exchange Commission of its existence and collectibility, and the condition that the same shall be held in escrow until actual payment of the amount. Financial instruments such as shares of stocks and bonds may be classified as personal properties, hence they may be legally accepted as capital contribution. Section 16. No transfer, however, shall be valid except as between the parties until the transfer is recorded in the books of corporation, showing the names of the parties to the transaction, the date of the transfer, the number of the certificate or certificates, and the number of shares transferred. The commissions may be required corporations whose securities are traded in trading markets and which can reasonably demonstrate their capability to do so, to issue their securities of shares of stock in a certificated or scrip form in accordance with the rules of the Commission. No shares of stocks against which the corporation holds any unpaid claim shall be transferable in the books of the corporation. In shares of stock, unit of interest in a corporation, its intangible personal property and may be issued by the corporation even if the subscription is not fully paid. In certificate of stock, evidence of the holder's ownership of the stock and of his right as a shareholder, its tangible personal property, and may be issued only if the subscription is fully paid. The stock and transfer book is the basis for ascertaining the persons entitled to the rights and subject to the liabilities of stockholder. Where transfer is not yet recognized as a stockholder in a corporation is under no specific legal duty to issue stock certificates in the transferee's name. First, the certificate must be signed by the president or vice president, countersigned by the secretary or assistant secretary, and sealed with the seal of the corporation. Second, delivery of the certificate is an essential element of its issuance. Third, the par value as to par value shares of the full subscription as to no par value shares must be fully paid. Fourth, the original certificate must be surrendered per the person requesting the issuance of the certificate to transfer from a stockholder. What is the meaning of unpaid claim? The term unpaid claim refers to any unpaid claim arising from unpaid subscription and not to any indebtedness which a subscriber or stockholder may owe the corporation arising from any other transaction.
Hi, my name is Marbian Alfarnon and I'm going to report section 63 until section 67. So, you can pause this part to read the section 63. So, section 63 is the issuance of stock certificate. So, what do we mean by stock certificate? Stock certificate is a written evidence of the ownership of a stockholder in a corporation. So, as you've read the Section 63, the main purpose of this prohibition is to prevent the arrangement of the subscription which in partial payment only. The reason why the partial payment should not be permitted by the corporation is because if the subscribers becomes delinquent in the payment of a subscription, the corporation will face a problem where they need to find money for the balance that is not yet paid by the subscribers. Because the corporation may not be able to sell as many of his shares as would be necessary to cover the amount due from him. And it is authorized under Section 67. So later on, we will discuss more about Section 67. So let's have an example for Section 63. So assume that D subscribe 5 shares at a par value of 20,000 each share in ABC Corporation and has a total subscription of 100,000, and then D made an initial payment of 60,000 pesos only. So in this example, the board of directors has the first option to apply the 60,000 as a full payment for 3 shares and issue a certificate for stocks for 3 shares only. The second one is the payment pro rata, meaning the entire 5 shares is paid only for the amount of 12,000, in which case no certificate of stock shall be issued until balance of 40,000 is fully paid. However, the first alternative can't be used if it is prohibited by the bylaws. If the board of directors declares that the payment of 60,000 will be used as a payment pro rata, meaning there will be no certificate of stock issued unless the balance is fully paid already. You can pause this part to read Section 64, which is liability of directors for watered stock. So, what do we mean first by watered stock? So, watered stock is a share issued as fully paid when in fact the consideration agreed and accepted by the directors of the corporation was something known to be much less than the par value or issued value of the shares. So basically, watered stock is the stock that was issued or being availed of that is lower than its par value. So, who is liable for watered stock? Like we have on the title, all the directors and officers who gives consent to the issuance of watered stock will be liable personally unless the directors or officers will object. So that the objection should be in written, otherwise he will be liable solidarily with the stockholders concerned to the corporation and to the creditors. So let's discuss solidarity liability with the stockholders concerned. So the difference between the fair value received at the time of the issuance of the stock and the par or issued value of the same will be the liability of the board of directors or the stockholders that are concerned. So, the issuance of a watered stock is not merely ultra vires but is illegal as it is a violation under Section 61. Now, who is liable for the watered stock? Like what I've said earlier, the liable for watered stock is the one who gives consent, which is the directors or the officers, and the one who availed the watered stock that was issued, which is the stockholders. So the reason why the issuance of watered stock is prohibited is because it is to secure the equality among subscribers and prevents discrimination against those who have paid in full, and most especially it is to protect the persons who may acquire stock and those have potential to be a creditor of the corporation. So let's have an example for section 64. So B, the director of YG company, issued a stock to A with a par value of 10,000 and only 8,000 is being paid by A, but the stock is issued as fully paid by B. Then the stock is considered as watered stock to the extent of 2,000, and that is the difference that B and A is liable for. The case is the issue itself is not void. However, the agreement that the stock shall be paid in less than its par value is illegal and cannot be enforced since it is a violation under Section 61. So let's talk about Section 65, which is interest on unpaid subscriptions. So you can pause this part to read the Section 65 for better understanding. So basically, under this section, it conveys that all subscribers who have unpaid subscriptions should be liable to the corporation's interest rate. So the interest rate should be stated on the subscriptions contract. However, if not, the legal rate will be applied. So before, the legal rate is about 12% per annum. However, now it became 6% per annum only. So if the interest rate is stated or stipulated on the subscriptions contract, let's say the corporation's interest is 8%, then the subscribers should be paying the interest of 8%. However, like what I've said earlier, if the interest rate is not stipulated or not stated on the subscriptions contract, then the legal rate will be applied. So let's discuss about Section 66, which is payment of balance of the subscription. So you can pause this part to read the Section 66 for better understanding. As to unpaid balance of the subscribers, it is the decision of the Board of Directors to state the due date for all the unpaid subscriptions, and if the whole amount or such percentage will only be collected, as well as the interest of the unpaid subscriptions. The decision of the Board of Directors will only prevail if the due date is not stipulated on the subscriptions contract. However, the failure of payment within 30 days from the specified due date, meaning all of the stocks covered by the subscription, will become delinquent and subject to sale unless the Board of Directors orders otherwise. Now we have remedies to enforce payment stock subscription. The first one is extrajudicial sale at public auction. It permits the corporation to put up unpaid stock for sale and dispose of it for the account of the delinquent subscribers, and it's governed by the Section 67 until Section 69. So the second one is the judicial action by court action, and it is provided under Section 70. The third one is the collection from cash dividends and withholding stocks dividends, and it's under Section 43. So now we will talk about delinquency sale under Section 67. So you can pause this video to read the Section 67 for better understanding. So a stock will be treated as delinquent once a particular stockholder failed to pay upon the specified date as stated at the subscription contract. The corporation has two remedies to sell a delinquent share. The first one, it can be judicial, meaning by filing a case in court, or extrajudicial, meaning the corporation is not required to go to the court in order to sell a delinquent share. So we have procedure of delinquency sale. The first one is sending of the notice of call. So what do we mean by call? So call means the demand to pay. This notice will be sent by the board of directors for the stockholders to pay the balance of their subscription. When you acquired or subscribed to a share of a stock, the specified date when you need to fulfill the payment is stated on the subscriptions contract. However, if there's no date being specified in the contract on when you need to fulfill the payment of the share, then it is payable upon call or notice of the call from the directors. So we have three requisites for a valid call. The first one is it must be made in the manner prescribed by law. The second one is it must be made by the board of directors. And the last one will be it must operate uniformly upon all shares. Second procedure is the notice of call must be received by the stockholders personally or through registered mail. The third one is if the stockholders fail to fulfill the amount due or the balance on the specified date in the notice of call, then the board of directors shall issue by resolution a notice of sale. So after notice, a publication in a newspaper of general circulation in the province or city where the principal office of the corporation is located, and then the period of the publication is once a week for 2 consecutive weeks, and then the contents of the notice of sale or the amount due on each subscription plus accrued interest, the date, time, and the place of the sale is also included. So in a public auction, the highest bidder is the one who is willing to pay the amount of the balance of the subscription for the least number of shares. And then the last procedure is after the bidding, the corporation will give the highest bidder the certificate of stocks in the number of his bid.
Hi, I am Janica Comia and I will be discussing Section 68 and the rest of the topic from Title 7, Stock and Stockholders. So, Section 68, when sale may be questioned. So, no action to recover delinquent stock or sold can be sustained upon the ground of irregularity or defect in the notice of sale or in the sale itself of the delinquent stock. So, unless the party seeking to maintain such action first pays or tenders to the party holding the stock the sum for which the same was sold, with the interest from the date of sale at the legal rate, no such action shall be maintained unless a complaint is filed within 6 months from the date of sales. So, ang hina-highlight nito is no action shall be maintained unless a complaint is filed within 6 months from the date of sale. So, nabanggit sa Section 66 na magiging delinquent yung stock if there is no payment made within 30 days from the said date. And nabanggit din sa Section 67 na delinquent stock shall be sold to the highest bidder unless the board of directors otherwise order. So, kahit ikaw yung highest bidder, kung ayaw sa'yo ibenta ng board of directors, hindi nila sa'yo isosold yung delinquent stock. Okay, there are 2 grounds for the recovery of stock unlawfully sold for the delinquency. The irregularity or defect in the notice of sale. Notice of sale kapag hindi na properly followed yung procedures at publication of sale, magiging void yung action. Second is irregularity or defect in the sale itself of the delinquent stock. Kapag, kunyari, hindi na fully paid yung isang delinquent stock pero nasold pa rin siya, defect na siya sa sale itself. Section 69, no court action to recover unpaid subscription. So, nothing in this code shall prevent the corporation from collecting through court action the amount due on any unpaid subscription with accrued interest, costs, and expenses. Laging kasama yung tatlo kapag babayaran yung subscription. Diba there are ways sa payment ng subscription? Voluntary and non-voluntary. Sa non-voluntary, there are 2, extrajudicial and judicial action. In this section, judicial action siya, na instead na public auction yung mangyayari, dadaan muna sila sa court kung saan i-compel nila yung delinquent stockholder na magbayad or bayaran yung subscription niya. The corporation can collect by action in court of proper jurisdiction amount due on any unpaid subscription with accrued interest, costs, and expenses. Section 70. Effect of delinquency. No delinquent stock shall be voted for, be entitled to vote, or be represented at any stockholders meeting, nor shall have the right entitled to a stockholder except in the right of dividends in accordance with the provision of this code for the amount due on the subscription with accrued interest and cost and expense of advertisement, if any. So, delinquency effect is you shall not be entitled to vote and be voted or represent at any stockholder meeting, nor shall have the right of a stockholder, except for the dividends and until or unless the payment is made. So, in other words, he is not entitled to his right as a stockholder. However, he is entitled to his right to dividends. Section 71. Right of unpaid shares, non-delinquent. So, holders of a subscribed shares not fully paid, which are not delinquent, shall have all the right of a stockholder. Unpaid pa lang naman yung shares niya, hindi pa delinquent. So, magiging delinquent lang siya if there is no payment made within 30 days from the said date, diba? Gaya nyo nabanggit sa section 66. So, hindi pa naman delinquent, unpaid pa lang siya. Therefore, he shall have the right of a stockholder pa, which the right to vote, be voted, participate in the dividends based on his total subscription. However, he is liable for interest on his unpaid subscription if required by bylaws. But the moment the unpaid subscription become delinquent, he loses some rights. So, the holder loses some rights. Mamaya babanggitin ko kung ano yung mga rights nila as a stockholder and liabilities. Section 72. Lost or destroyed certificates. The following procedure shall be followed by a corporation in issuing new certificate of stock in lieu of those which have lost, stolen, or destroyed. So, kapag nawala yung certificate of stock, it does not necessarily mean na nawala na yung ownership niya because it's just an evidence na owner ka ng isang stock. Still, pwede kang isyuhan ng bago, but there are some procedure to be followed. I-claim ko na lang siya. First, registered owner of certificate of stock in a corporation or such person legal representative shall file with the corporation affidavit in the triplicate of the corporation. So, ano-ano yung mga laman ng affidavit? First is circumstances as how the certificate was lost, stolen, or destroyed. Second, number of shares represented by each certificate, serial number, name of the corporation which issued the same. So, kung ikaw nga talaga yung owner ng isang certificate stock na yon, dapat alam mo kung ano yung mga nilalaman nito at kailangan mong makumpleto yung affidavit. Second is the verification of affidavit by the corporation. Kailangan mo nang i-verify nila kung talagang sa'yo yon at nawala, nasira, or ninakaw yung isang certificate of stock. Third is publication of notice once a week for 3 consecutive weeks in newspaper of general circulation. Anyone wants to protest the issuance, they have 1 year to do so, and a person applying for certificate, he needs to wait 1 year before the issuance of certificate of stock. Except in case of fraud, bad faith or negligence on the part of the corporation and its officer, no action may be brought against any corporation which shall have issued certificate of stock in lieu of those lost, stolen, or destroyed pursuant to the procedure above described. So, pumunta naman tayo sa mga right of a stockholder, yung mga right nila. Meron silang tatlong right. Management right, propriety rights, and remedial rights. So, sa management rights, merong 7. First is to attend and vote or by proxy of a stockholders meeting, to elect and remove directors, to approve certain corporate acts, to adopt and amend or repeal the bylaws and adopt new bylaws. Fifth is to compel the calling of the meetings. Sixth is to enter into a voting. trust agreement. 7. And last, to have the corporation voluntarily dissolved. So, nabanggit na naman siya ng mga previous reporter, pinapaikli ko na lang. Pagdating naman sa propriety rights, it is a held property of a private owner. So, yung propriety rights ng stockholders. To transfer stock in the corporate book, to receive dividends when declared, to issuance of certificate of stock, to participate in the distribution of corporate assets upon dissolution. Last is to preemption in the issuance of shares. Remedial rights. Pagdating naman sa remedial right, is a right as a self-defense arising on a violation and of the protection for the substantive rights. So, first is to inspect corporate books, to recover stock unlawfully sold for delinquent payment of subscription. Third is to be furnished with most financial statements. Fourth is to bring suits, derivative, individual, and representative suit. Yung nireport ng previous reporter. Fifth is to demand payment in the exercise of appraisal rights. So, yun yung mga rights ng stockholders. Kung merong rights ang isang stockholder, meron din siyang liabilities. And yung mga liabilities nito is more on about unpaid subscription. First is liability for unpaid subscription. Second, liability for interest on unpaid subscription. Third, liability to creditors of the corporation on the unpaid subscription. Fourth, liability for watered stock. Fifth is liability for dividends unlawfully paid. So, yun yung mga summarize ng right ng isang stockholders and liabilities niya.
Pleasant day to each and everyone. I'm Lady Crystal Rosales and I'm here to report Title 8, Corporate Books and Records. Section 73, Books to be kept, Stock Transfer Agent. Every corporation shall keep and carefully preserve at its principal office all information relating to the corporation, which means the entity needs to take care and conserve the record of all business transactions, including but not limited to, first is the articles of incorporation and bylaws. Second, the current ownership structure and voting rights of the corporation, including list of stockholders or members, group structures, intra-group relations, ownership data, and beneficial ownership. For easy understanding, it is information relating to the typical corporation structure, which are the directors, officers, and shareholders. Third is the data regarding the governing body or board of directors. Fourth, a record of all business transaction. Financial statement is one of its example. Fifth, it includes record of the resolutions of the board of directors and of the members. Copies of the latest reportorial requirements that is required to be submitted to the commission. And last is the minutes of all meetings of stockholder and board meetings. May mga bagay na kailangan ilagay sa minutes ng detalyado at ito ay ang mga sumusunod. First is yung time and place. Second, how it was authorized. Third is the notice given. Fourth is the agenda, type of meeting, and if it's special, object is needed, present and absent during the meeting, and last is the finish act during the meeting. There are books that are required to be kept by a corporation, which are stated in the following. First, books for the minutes of stockholders and board of director meetings. Second, record of transactions of the corporation. Third, the stock and transfer book. And fourth, other books required to be kept under Section 74. Ngayon ang tanong, sino nga ba ang mga tao na may kapangyarihan para tignan ang corporate books? Who are authorized or given by law the right to inspect the corporate books? First, director, trustee, stockholder, or members. Second, the voting trust certificate holder. If we do remember, the voting trust agreement or VTA, stockholder can mortgage or pledge the shares of stocks in favor of his creditor to secure the payment of a loan. For example, isa akong stockholder and umutang ako kay A dahil wala akong property para ma-secure ang loan. Ang share of stock ang ginamit ko to secure for the loan or for the payment of loan. If you have pledged your shares of stock in favor of your creditor, as a stockholder, I have to execute a loan contract, which is the principal contract and a voting trust agreement. The voting trust agreement has the effect of making the creditor trustee the present stockholder, because if we execute the VTA, the shares of stock standing under the name of the debtor will be cancelled and a new certificate of stock will be issued in favor of the name or under the name of the creditor. If the certificate of stock has been transferred under the name of the creditor, pursuant to a voting trust agreement, then the creditor will now become the stockholder of the corporation. And since the share of stock are now standing under his name, he has now the right to demand inspection of the corporate books. If the certificate of stock has been transferred under the name of the creditor, pursuant to a voting trust agreement, then that creditor will now become the stockholder. He will now become the stockholder of the corporation under his name. He has now the right to demand inspection of the corporate books. Take note that in a voting trust agreement, it is the certificate or the voting trust certificate holder or the trustee creditor who can demand the inspection of the corporate books. Ang mga stockholder ay may propriety rights para i-inspect ang corporate books dahil ang stockholder ay type ng investor. Kung gusto nila makita ang lagay ng corporation or status ng corporation on financial status, they can check the book. Each stockholder can demand to inspect the corporate books. The question is, what will happen to the debtor or previous stockholder? Now, unless and until that the shares of stock issued under the name of the trustee creditor has been reverted back to the obligor debtor, former shareholder, then he has no right to demand inspection of the corporate books. The third person who has right to inspect is the stock of sequestered company and beneficial owners of shares. When we say beneficial owner, for example, you have a sibling or a relative working abroad. He or she wants to purchase a property in the Philippines. The case here is that he or she has no time to process the transfer of ownership over a property under his or her name. My relative, for example, may ask me to put the ownership of title of the property under my name, which is mapapangalan muna sa akin, which in fact hindi naman talaga ako yung may-ari. Kung may relative ako and ang tawag sa relative ko na owner, what they call is the beneficial owner, where the relative who is the real and true owner, and then the one on the other person under whose name the property is registered is called the naked owner. So, tawag sa akin is naked owner. The beneficial owner of the shares can also demand inspection of the corporate books. Stockholder ay inabuse ang power niya at ginamit ang corporate books kung saan-saan siya ay magiging subject to punishment under Revised Corporation Code Section 150. Pwede bang hindi pumayag ang officer na ipakita ang corporate books sa shareholder? No, hindi pwede mag-refuse ang agent. Nakasulat ito sa law under Section 161. But the stockholder may not demand inspection of a corporate books if such inspection will result in the revelation of the trade secrets. Can the shareholder hide its name in the corporate books? So, pwede nga bang itago sa corporate books yung pangalan niya? Yes, by finding a trusted person to purchase the shares of stock of another corporation and register the shares of stock under his name. Now, the question is, how will the true and real owner protect its shares? The beneficial owner needs to prepare and draft a deed of or declaration of trust. Declaration of trust means merong trustor and merong trustee. Yung trustor, siya yung beneficial owner. And the trustee is the one and is the person under whose name the property is registered. The beneficial owner or the trustor can also have the right to demand for the inspection of the books, because in the first place, he or she is a stockholder. On the off chance that the corporation denies or doesn't follow up on an interest for review as well as propagation, the wrong party might report such to the commission inside 5 days from receipt or such report. The commission will lead an outline examination and issue a request coordinating the investigation or proliferation of the mentioned and records. Under the Bank Secrecy Law, only the depositor can allow inspection of any information relating to this bank deposit in the absence of a written consent or permission from the particular depositor. The bank may not disclose any information relative thereto, otherwise they will incur criminal penalties under the Bank Secrecy Law. Stock corporations must also keep a stock and transfer books which contain the following: all stock in the name of the stockholders alphabetically arranged. After registering the corporation with SEC or the Commission, they will issue STB. Again, STB refers to the place or book where we record every portion of shares of stock and current subscribers of the corporation. Second is the installment paid and unpaid on all stock for which subscription has been made, and the date of the payment of any installment. Looking back on the past lesson, the unpaid subscription, it can be paid on the date indicated on the subscription contract, or upon the date of call by the board of directors. Through a deed of sale or assignment, stockholder can transfer the shares of stock to another person. For example, namatay yung stockholder, then the heirs of the stockholder will have the right para manahin ang shares of stock na naiwan ng yumao na stockholder. These transfers are recorded in the STB or the stock and transfer books or book. Nakalagay din sa STB yung certificate of stock, number, name of the stockholder, number of the shares of stocks held under such name. The shares of stock has been transferred to another person, then we have to cancel that entry in the STB and issue another entry in favor of transferee, and that is how the STB is being kept by the corporation. And then, such as other entries as may be provided by the bylaws. A stock transfer agent or one engaged principally in the business or registering transfers of stock in behalf of the stock corporation shall be allowed to operate in the Philippines upon securing a license from the Commission and the payment of a fee to be fixed by the Commission, which shall be renewable annually. Now, Section 74, Right to Financial Statement. Who makes an entry in the STB? The corporate secretary is the one who is responsible for making entries and in keeping the STB. Board of directors or trustees are in charge with the management of the corporations. It is the board of directors' duty to present the annual financial report to a stockholders at the regular meeting. For stockholders to know the detailed assets and liabilities and results of operation, in which the corporation shall furnish to stockholder the most recent financial statement within 10 days from the receipt of a written request of any stockholder or member. Financial statement is duly signed and certified in accordance with the RCCP and the rules the SEC may prescribe the financial statement. The financial statement includes the balance sheet and profit and loss statement for the said year. Apart from this financial statement, must be audited by an independent certified public accountant when the paid up capital is 600,000 and above. Except that if it's less than 600,000, then financial statement may be certified under oath by the treasurer and the president. What is the basis of the stockholder's right to demand inspection of the corporate books? And why has the law given the right to the stockholders to check the books of the corporation? Sabi dito sa Section 74, as owners of the assets and property of the corporation, stockholders should be entitled to the right of inspection, which is predicated upon the necessity of self-protection. Take note of the following of the limitations by the law on the right to inspect the stocks and transferable. First limitation, right must be exercised during reasonable hours in business days. For example, hindi ako pwede mag-demand ng inspection at 12 midnight because this right can be exercised only during reasonable hours. On business days or office hours, like for example, Saturday is not business day. Therefore, I do not have a right as a stockholder to demand inspection of the books under Section 74 of the Corporation Code. Second, the person demanding the right has not improperly used any information obtained through any previous examination of the books and the records of the corporation. Third, the demand is made in good faith or for legitimate purpose germane to his interest as a stockholder. Fourth, it should follow the formalities that may be required in the bylaws. Take note in the fifth limitation that the right to inspect corporate book does not extend to trade secrets. Trade secrets, for example, AI Corporation, which is engaged in the invention of some technology or is a corporation engaged in robotics, and that there are some of certain trade secrets that the company would like to protect, and that information is not readily available in the public. Then, you do not have the right to inspect the books because otherwise, if you are granted inspections of the books, then the trade secrets will be disclosed or revealed open to the general public. There are corporations, for example, catering or restaurant business, na meron siyang trade secrets in the recipe on how a particular food is being prepared, which is protected by the intellectual property law. For example, the manner by which a particular pastry is baked. These trademarks are protected by law. Take note also on the last limitation, 6, it is subject to limitations under special laws. Example given is Secretary of Bank Deposits and FCPA or the Foreign Currency Deposits Act. We have a law protecting the absolute confidentiality of all bank deposits, be it peso deposit or foreign currency. Because of the absolute confidentiality of these bank accounts, this will serve as a limitation on the right of the stockholders to demand inspection of the corporate books.
Hi guys! Welcome to a new lesson of Hiromi and Iris. Today, we will discuss the Title 9, Merger and Consolidation of the Revised Corporation Code of the Philippines. I am Hiromi Lagbao. I will discuss or explain the Section 75 and 76 of the Revised Corporation Code of the Philippines.
So, what is merger and what is consolidation? The merger is when a corporation absorbs the other and remains in existence, while the others dissolve. The remaining is the one that survives and continues the combined corporation. Example, A plus B is equals to A or B. Depends on who will survive. So, the one who survives acquires all the rights, privileges, powers, and liabilities, while consolidation is two or more existing companies in which establish a new entity. Example, A plus B is equals to C. So you see the combination of A plus B, which will create a new entity, which is C. So another information, which is constituent corporation. So constituent corporation is called the parties to a merger and consolidation. So in merger and consolidation, there is no liquidation of asset because the surviving corporation automatically acquires all the rights, privileges, powers, and liabilities. Section 75, the plan of merger and consolidation. So, it is a plan that is created by the representatives of the constituent corporations that will be approved by the board of directors or trustees by each corporation. The plan contains the name of the corporation involved, or what we call constituent corporation, which is the merger and consolidation. Second, terms and conditions of carrying the merger and consolidation.
Third, statement of changes, if meron, for example, the present articles of surviving corporation or merger, or the article of the new corporation or consolidation must be set forth para sa articles of incorporation as organized under the provisions. Fourth, such other provision with respect to the proposed or merger consolidation are deemed necessary or desirable. So, sinasabi sa fourth na basta kahit na yung ibang provisions na i-respect yung merger or consolidation is kinakailangan at ginugusto nila.
Section 76, stockholders or members approval. So after the planning, which is discussed in Section 75, it must be submitted to the stockholders and members of each corporation for approval. The voting requirements, affirmative vote of stockholders representing 2/3 of the outstanding capital stock of each corporation, or if it's in case a non-stock corporation, the 2/3 of members. The voting requirements for amendment of plan or of merger or consolidation, majority of the respective board of directors or trustees of all constituent corporation and ratified by affirmative vote of stockholder representing the 2/3 of the outstanding capital stock or 2/3 of members of each constituent corporation. So all of the voting requirements are the same, but always remember the majority vote of directors or trustees of each corporation, then ratified by the affirmative vote of stockholders representing 2/3 of the outstanding capital stock, or 2/3 member in case of non-stock corporation. The rights of appraisal of dissenting stockholders shall be respected, but if after the approval by stockholders of such plan, the board of directors decide to abandon the plan, the right of appraisal shall be extinguished. For example, so the right of appraisal of dissenting of stockholders on the plan is available. Kaso nga, kung na-approve ng stockholders and napag-decide ng board of directors to abandon the plan, edi wala na yung right of appraisal. So, dun lang siya sa pag-submit ng approval of plan of merger or consolidation, edi dun lang magiging available yung the rights of appraisal.
Section 77, Articles of Merger or Articles of Consolidation. Following the approval of the stockholders or members of the corporations, as required by the preceding section, each of the constituent corporations must execute Articles of Merger or Articles of Consolidation. So, dapat daw meron silang gagawing Articles of Merger or Consolidation. You should take note of this. Those articles of merger or consolidation must be signed by the President or Vice President and certified by the Secretary or Assistant Secretary of each of the corporations, setting forth the following. Letter A. The plan of the merger or the plan of consolidation. For example, the corporation A and B are to be merged or consolidated, etc., etc. Letter B. As to stock corporations, the number of shares outstanding, or in the case of non-stock corporations, the number of members. Letter C. As to each corporation, the number of shares or members voting for or against such plan, meaning those who are in favor or not about the merger or consolidation of both corporation. Letter D, the carrying amounts and fair values of the assets and liabilities of the respective companies as of the agreed cut-off date. Letter E, the method to be used in the merger or consolidation of accounts of the companies. Letter F, the provisional or pro forma values as merged or consolidated using the accounting method. Of course, when two companies are to be merged or consolidated, there will be certain rules and accounting methods to be used. And lastly, letter G, such other information as may be prescribed by the Commission.
Section 78. Effectivity of merger or consolidation. Since the merger or consolidation is such a significant event, as said in Section 78, it should, or the articles of merger and of consolidation must be performed by the SEC, or the Security Exchange Commission. Basically, it needs the approval of a regulatory body for it to become a valid and effective merger or consolidation, provided that in the case of merger or consolidation of banks or banking institutions, loan associations, trust companies, insurance companies, public utilities, educational institutions, and other special corporations governed by special laws, the favorable recommendation of the appropriate government agency shall first be obtained. So, for example, kapag bangko yan, central bank. Kapag educational institutions yan, DepEd or CHED. Insurance company, for example, PDIC, Philippine Deposit Insurance Corporation. So, the favorable recommendation for those is the appropriate government agency shall first be obtained. The corporations need the approval of the SEC if the Commission is satisfied that the merger or consolidation of the corporations concerned is consistent with the provisions of the Code and other existing laws, it shall issue a certificate approving the articles and plan of merger or of consolidation, at which time the merger or consolidation shall be effective. Next paragraph. Sinasabi rito, paano kapag nagkaroon ng problema? If upon investigation, the Commission has reason to believe that the proposed merger or consolidation is contrary to or inconsistent with the provisions of this code or existing laws. For example, yung anti-competitive laws, SOSI Globe and CPLDT nag-merge or nag-consolidate. Itatawag na doon is monopoly or duopoly sa industry natin. Kasi both companies are big companies, di ba? Makawalan na ng competition sa industry at malaleft out na yung small telecom na companies, which is detrimental to the economy of the country. So with that, pwede sila ma-disapprove ng SEC or Security Exchange Commission to prevent the duopoly event. So ang process dito, it shall set a hearing to give the corporations concerned the opportunity to be heard. Written notice of the date, time, and place of hearing shall be given to each constituent corporation at least 2 weeks before said hearing, and the Commission shall thereafter proceed as provided in this. So there are steps necessary to accomplish a merger or consolidation of the corporation code. These are: number 1, the board of each corporation shall draw a plan of merger or consolidation. And yung plan na yon must include any amendment, if necessary, to the articles of incorporation of the surviving corporation, or in case of consolidation, lahat ng statements that is required sa articles of incorporation ng corporation. Number 2, after the board has planned, submit the plan to the stockholders or members of each corporation for their approval. So, dapat may meeting and at least 21 days notice must be sent sa lahat ng stockholders or members, personally man yan or by registered mail. Then, the summary of the plan must be attached to the notice. A vote of 2/3 of the outstanding capital stock will be needed, as said in Section 76 by Hiromi kanina. Appraisal rights, when proper, must be respected. Number 3, execution of the formal agreement, referred to as the articles of merger or consolidation, by the corporate officers of each constituent corporation. Again, take note that under Section 78, it requires the approval by the Securities and Exchange Commission of the articles of merger, which in turn must have been duly approved by a majority of the respective stockholders of the constituent corporations. Meaning the merger does not become effective upon the mere agreement of the constituent corporations. The merger shall be effective only upon the issuance by the SEC of the certificate of merger. By the operation of law, upon the effectivity of the merger, the absorbed corporation ceases to exist, but its rights and properties, as well as liabilities, shall be taken and deemed transferred to and vested in the surviving corporation. The same rules applies to a consolidation, which becomes effective not upon mere agreement of the members, but only upon issuance of the certificate of consolidation by the Security Exchange Commission.
Section 79. Effects of merger or consolidation. So, ano nga ba magiging epekto if the two corporations will merge into one entity, or two corporations will merge to produce a new corporation? The merger or consolidation shall have these following effects. Letter A. The first effect, when two corporations shall become a single corporation. In the eyes of the law, pag nag-merge na, it is considered as a single corporation.
Letter B. The separate existence of the constituent corporations shall cease or shall end. Non-existent na dapat yan, except yung surviving or yung consolidated corporation.
Letter C. Just like na na-discuss kanina, whoever survives or consolidated or the consolidated corporation shall possess all the rights, privileges, immunities, and powers, and shall be subject to all the duties and liabilities of a corporation under this code.
Letter D. Moreover, yung franchises of each personal property ng corporations, all receivables due on whatever account, including subscriptions to share, other choices in action, and every other interest of belonging to or due to constituent corporation, dapat matransfer at maibigay na sa surviving or consolidated corporation. Those following said without further act or deed.
Letter E. The surviving or consolidated corporation shall be responsible and liable for all the liabilities and obligation of each constituent corporation. If the two corporations combined, all of the liabilities and obligation will transfer into a new corporation. So, like said earlier ni Iris, if shares or assets are to be transferred sa merged or consolidated corporations, yung remaining or existing liabilities and responsible din ng bawat constituent corporation will be transferred sa new merger or consolidated corporation.